Hey, good afternoon. This is Carl Blackstone with the Columbia Chamber. We thank you all for joining us on this call today. Over the last few weeks, the Chamber has been getting lots of questions regarding a host of things concerning coronavirus, and the information is so fluid. But when we sent out a questionnaire earlier this week, the number one issue that came back were regarding labor issues and dealing with employees in this uncertain time. And so I reached out to our friend Kathy Helms at Ogletree, and she was gracious enough to give us a little bit of time today to answer questions that y'all might have. And so for those that have not met Kathy, she is with the Ogletree firm. She's the managing shareholder here in Columbia, but she is part of their rapid response team for dealing with coronavirus within Ogletree. She's an expert in many fields, but this is just she'll say this as well. This is not intended to be legal advice for y'all, but things to think of, and for if you want to call Kathy after the fact, I'm sure she'd love to talk to you, but this is intended for information only. So with that, Kathy, welcome, and thank you very much for taking the time to be with us.
Carl, thank you. And by the time we get off this call, there will be some things that have changed again. I've practiced law for 35 years, and I've never seen things like this. And part of it, we can give legal advice on some things, and there are things we're all just feeling our way through. And one of the and I've been working on this since late December. We started off with 2 attorneys on our team handling most of the calls, and we quickly had to expand to not just more attorneys getting up to speed on it to be able to handle the volume of calls we've had, but also a number of subject matter experts, because there are so many specialized questions in this, from benefits to OSHA issues to WARN and all different sorts of things. So our group has grown quickly, and as well as the situation had to be fluid, and we're constantly, we were keeping track, for instance, of all of the emergency declarations and the impact of those, and they were becoming so common that we had to just go tracking all of the state ones. The South Carolina one doesn't have a ton in it right now, unless you're in one of the specific businesses impacted. And I am doing pickup at restaurants to try to do my part, but there isn't a whole lot there yet. The other thing we've been watching in South Carolina is the unemployment comp piece there, and there are a couple of things I noticed in that. One, the 7-day waiting period has not yet been waived, and apparently there may be an issue with the ability to waive that. And secondly, that when, I believe I read it correctly, but it's my understanding that when the unemployment compensation is paid to someone because of the coronavirus, that is not charged back to the employers. So that is a good piece of that, right. And it means that can be done to help these folks who are hurting, and at the same time, hopefully not hurt the employer at all. And part of what we're seeing in the legislation is that balance where, and quite frankly, the Senate bill just now passed. They're voting. Anyway, what we're seeing is, first of all, we were getting hit with the COVID-19 information, and then it became evident very, very quickly that there were economic issues, huge economic issues that were going to become part of that as the social distancing came into place and various other issues. So this is, as you all know, it doesn't take great legal knowledge, but this is incredibly complex. We are not looking at a situation where we might have to deal with a few employees being out for 2 weeks or 14 days for quarantine. We're looking at something that more likely is going to have a much longer, deeper impact. And so where initially what I was hearing is that if someone was sent out to quarantine because an employer felt that was the safer avenue to take, most employers were saying, we'll pay for that time out. We don't want that to hurt. Now that they know that they may be looking at rolling and having people out for 14 days or more for longer periods, and apparently this could come in waves and actually repeat, but employers are looking at the fact that this may not be something that's just going to hit for a couple of weeks, and so they're having to rethink whether or not they can do that. This new bill is going to certainly impact that. While I run this office and I deal with all the employee issues, I don't run it from the business standpoint of things, so I don't know to what extent these tax credits in this bill are actually going to help all of our small businesses when they have to pay out these various leaves under the Family First Act. So that's certainly a consideration and a concern, but those are things that are new and that we're going to have to deal with. Our guy in D.C. has told me today that they're looking at least a 3-part fix, if you will, to this, and so additional parts coming to that. We do think it will go above 500 employees, and there may have to be some fixes to what has gone into apparently about to be voted in. The reason I had seen where someone thought it had passed at 2 o'clock today, but apparently there were a number of amendments that were offered, and those were being voted down. So I believe, my impression is, the bill that should pass the Senate, if it gets 60 votes, will be substantially the same as what the House had. The House originally passed it, I think, at 1 o'clock on Saturday morning, and there were some technical errors, so they had to go back and in the last 2 days pass it again, and then it went to the Senate. So that's kind of what we know there. Carl knows we did this pretty quickly, so I don't have a perfect outline of things to go over. I really want to go over things that are impacting you guys, and I don't know to what degree y'all have people who can work remotely. Let me just say very quickly, if you don't already look at it almost daily, you need to, because the CDC page and guidance is changing frequently. And it's cdc.gov, and you can look at the tabs, and there is one for business, and that is I won't say it's invaluable, but it's about as good as we've got right now for information to follow. I wish they were more specific on some things, but one of the most useful tools that they have is the risk assessment that lets you know whether or not someone needs to be sent home, and who you need to follow up with that. One of the things early on, I think I dealt with my first positive case 3 weeks ago, and it was actually someone who was traveling and went to the hospital, and the hospital tested him in his car and gave it his test result, and he tested positive, and they told him to go back to the hotel because they didn't have anywhere to send him then, and so it kind of became the hotel's problem very quickly, and they needed to know who had dealt with him. Now, the interesting part of that to me was that the local health agency came in and fed him and brought him water, and they were the only ones that dealt with him, and the room was sealed off. And then finally, after 2 days, they made arrangements to move him, and they gave the hotel very specific instructions of who a service was that would be good to have it cleaned, how long it needed how long of a time period there needed to be before another person came in there or before anyone else came in the room, and the health department was able to really give them excellent guidance. And it would be great if we could all assume that we would have that in every case. I think we're already finding that many health departments are overwhelmed. If they're not overwhelmed, they're working at full capacity. So their ability to guide employers is going to become less and less. The same thing I understand. I was talking to some folks who were trying to call the CDC to get some guidance over the weekend, and they said, it's just anyone who calls there now is going to get a busy signal. So we all have to try to figure out what to do as the best we can. And Carl, I mean, I'm just kind of floundering here, going through some things, trying to think of. On that note, I'll say one thing. One question that I have gotten a million times is about temperature taking, and we had really struggled with that. And the EEOC actually came out with some updated guidance today for the first time, because all we had before that was based on their 2009 H1N1 guidance. And they have today said that, and let me backtrack there a little and explain. The problem with taking temperatures is that it is considered a medical examination. If you're covered by the Americans with Disabilities Act, you can only do medical examinations in certain instances. Any employer or any employer covered can only do, with 15 or more employees, can do medical examinations. Taking someone's temperature is a medical exam. So we really had to be in a position that if people were going to do that, there had to be a direct threat in the workplace. That's a really high standard to meet. So initially we were really saying you need to stay away from that. Also, sometimes they can be, well, you can have someone with COVID-19 and they may not have a temperature. You can have people who are positive who are asymptomatic. So we felt like there were enough concerns initially that we couldn't go there. And from a legal standpoint, we didn't feel like that the law clearly allowed it. When the World Health Organization declared that there was a pandemic, the CDC essentially adopted that, although not outright, but they began to use that language. That moved it a whole lot closer that we were in a situation where taking someone's temperature would be allowed. It has now the EEOC came out with guidance today that clearly allows for it. So that can be done. You have to be really careful if you do that, however, because strange as it is, even if this isn't a disability, and generally just having COVID-19 is not going to be a disability. If it causes you to have pneumonia and all sorts of other things, or if you have underlying conditions, it exacerbates. It potentially can be a disability, but you have to, even if you have a situation where it's not a disability, the confidentiality provisions of the ADA continue to apply. So if someone's temperature is taken, that information has to be held as a confidential medical information. So to the extent, or I shouldn't say to the extent, because you should already keep any medical information separate from regular personnel information, but this would be treated in that same manner. This goes to another huge issue. If you have someone treated or someone who is found to have COVID-19 or displays the symptoms, so you send them home, and you need to talk to the other people in your business, and to what degree and who all you talk about or talk to, it really depends. But you certainly want to talk to the folks who work directly with this person. You can't identify that person because of the confidentiality issue under the ADA. So we all know that if you have 5 people that work in one area and you say we've had someone test positive, they're home, we want you to, the people who work closely would be sent home too and told to either contact their health care provider or self-monitor. And again, the CDC website has how you self-monitor and all the things you watch for, and it's all the things we've heard, like fever, cough, or upper respiratory distress, and I'm going to go totally blank on the other one right now. But all the symptoms are there, and you can have someone self-monitor for that. But when you talk to the other people in your business, or it can even perhaps be vendors or other people, if needed, you cannot say, you can't use a person's name. Like I was saying, there are times that everyone's going to figure out who it is, but you have to maintain that confidentiality. Now, one of the things that you'll need in order to trace who else might have been exposed is to talk to that person and get them to tell you who all they've worked closely with over the last 14 days. I would recommend that you do that over the phone after you've sent them home and not bringing them in your office to do it. I laugh because at one point early on in this, we had a situation where it looked like the employees were all being told to go in and talk to the HR people, and I said, y'all are going to wipe out your HR unit in about 2 days. So although we don't like to conduct business generally over the phone or by email, you want to tell people that, if they are having the symptoms, if they have concerns, or if they have been tested positive, to let you know over the phone or by an email, and then you can follow up. People are also asking, what can we ask? If someone says, I need to quarantine for 14 days, do I just have to let them? And that goes a little bit back to the disability and the FMLA issues, and it's no. You have the right to ask them what symptoms they're having. Have they been tested? Do they have a test result? I talked to an employer this morning that found out because someone posted it on Facebook. That's not necessarily acceptable. And if you have other rules, you have the right to keep those rules in place. And then you'll want to know basically how you're going to handle it. If you need to send folks out, who's going to talk to them, what's going to be said, those sort of things. Another thing we're hearing frequently is, can I require a note for them to come back, either a fitness for duty or something that says they actually tested positive or had symptoms. Again, I'll go back to the CDC. I'm a real broken record on this, but I'll go back to the CDC advice, and one of the things they ask is not to request a note for someone to return because of the weight that puts on our healthcare system, and we have to be very careful with that. The reality is, you may have someone who had direct exposure who goes out and never exhibits any symptoms and isn't tested. That doesn't mean that they didn't need to go out or that you didn't need to send them out. So getting a note in that instance would be almost impossible. On the other hand, if you get a situation where someone is tested, they are told to stay out, you can have them relay that information to you that, yes, I was tested and tested positive. I would be careful about asking for copies of anything because you don't want to ask for copies of medical records. So that is a little looser than most employers typically do any sort of absences, but we truly are in an extraordinary time. And what we're hearing from almost every end of the government is we're going to have some flexibility in here. And again, I keep going back to, I have not heard from a single employer, and I've been on these calls for about 14 hours a day, but I haven't heard from anyone who isn't doing their level best to protect the health of their employees and keep their business alive. And
that's a huge concern for everybody, Kathy. I'm going to let you catch your breath for 1 second. For those on the call, we got a bunch of you. What we want to do is open it up to some questions. We've had a list of questions that we've tried to address, or Kathy's tried to address early on, but it's going to be a little challenging with this many people. But if you have a question, if you could state your name and the question, and we'll do our best again. So Kathy doesn't have to say it. This is not considered legal advice, but we'll do our best to answer any broad level questions. Is that correct, Kathy?
And that's absolutely right, because specifics matter so often in these issues. But Carl, real quick, I have not really gone through all of these, and one of them I see that I think will impact a lot of people is the issue of whether or not you have to compensate someone if they're out.
Yeah.
And whether or not unemployment is going to be available. Yes, unemployment is going to be available. They may still have the waiting period. Some people may meet your plan requirements for short-term disability. That will be fact-specific. And thirdly, whether or not you compensate someone really depends, number one, on your current policy. It's going to depend somewhat on this new bill where that requires compensation. It'll have to be there. But the rules of thumb are if you have have people who are non-exempt, then you have to pay them for hours worked. You don't have to pay them for any more unless you have a policy that, for instance, guarantees sick leave or something to which they're entitled. But generally, you do not have to pay someone if they have to go out for a period of time like that. Now, initially, I was saying, we've got to think about that because that may not be a smart approach in the short term when we have almost zero unemployment, or I think it was under 3. Well, now the New York Times article today says there are worst case scenario, we could go to 20% unemployment. So everything's changing. But the bottom line is, and if most of you guys are not the huge corporations and the PR issues are just not the same, a lot of, you're seeing places like, well, y'all have seen the list of them, who are not paying workers who they're going out, and on social media they're getting hammered. That is really different from, say, a restaurant that has 20 employees. That it's a very different situation. So the bottom line on that is the law is that you pay non-exempt employees for time worked, and you have to be sure to do that. Now, there are some requirements. Some places we're seeing changes, either reductions in hours or reduction in pay, but still people keeping them on. In South Carolina, you need to give 7 days written notice for those changes. We hadn't seen anything waiving that yet, so that's important if you do that. Then there's the other bag of employees that are exempt employees, and when you can reduce their wages or not pay them is very technical under the Fair Labor Standards Act, and there are 7 exceptions. And the ones that we're looking at here really determine whether you, if someone works part of a week, you have to pay them for the whole week, basically. There are instances where you cannot pay them for one day, or if they're out the whole week, you don't have to pay them, even if they're exempt. So those are, again, very fact-specific, but there are avenues where an exempt employee may not have to be paid. But again, you want to be sure you meet all the criteria there, so you want to look over that and be sure you met that. But there will be any number of instances where people are not paid unless it's pursuant to this new legislation. Carl, I think that hits kind of some of the main points on these questions you sent me. So if there are any more, I'm glad to attempt to address them. This is stuff we could literally talk about for 3 or 4 hours and still have more questions. So I'm sorry it's kind of a 60,000-foot view.
Yeah. Well, thank you so much for that. And we've unmuted the line now. So if
the conference has been unmuted.
Uh-huh.
The conference has been unmuted.
So if anyone has a question, if you could just state the question and your name, that would be great.
How does your booth work?
Hi, this is Cam Barner, and I had a question on the new legislation. So when signed into law, if it is, would that apply retroactively to decisions, say, that was made the past 2 weeks?
I don't believe so. I think, as I recall, when I was looking through it, it says it becomes effective 15 days after it's passed, I believe is what the requirement was. So I have no reason to believe that it would go back and, for instance, if you had someone who had been quarantined last month, that you would have to go back and pay them. I haven't studied that closely, but unless there's some specific language in it, which I have not seen, then I know of no reason that would make it retroactive. Typically, any bill that is retroactive will specifically state that. One of the things that I think would cause a problem with that is because we had so little testing that I think people have been very, very careful to send people out quickly, and it might be hard to match it up. But I have not seen anything specifically stating that it's retroactive.
Yeah. Kathy, on that, one little bit of housekeeping. There's a lot of background noise. So if you don't have a question, if you could just mute your call, that would be very helpful so what everyone else can hear. We really appreciate that. And if you want to ask a question, just unmute and ask your question. Thank you. Next.
I could ask a question along those same lines, I'm curious as to then if you have an organization have chosen to pay them 10 days in anticipation of this legislation, but then it passes and it's effective 15 days later, are you then obligated to pay an additional 10 days?
That's an excellent question, and if you will give Carly your email, I will follow up with you. I don't know the answer to that, but I'll have to look at the way it's worded, because if it just says, to me that's almost as if you've met the requirements of the Act, that if someone had to go out, or say someone's out for 14 days and this passes in the middle of it and you've already paid them a week, would you get credit for that, or would they get another week? And my guess is there is an argument there that you would not have to pay them again, but I would like to look at that, and I'll be glad to follow up if you'll send your email to Carl, and I can do that.
Okay, thank you.
I have not studied it to that. Y'all are going to grill me on stuff I hadn't learned yet on this, but just thinking the way legislation normally works, I think you would have a good argument there. Now, one thing is, just because this has payment for something doesn't mean someone should be able to stay out a longer period of time. And one of the things we've been emphasizing there, if someone is sent out and told to quarantine for 14 days, but during that time they're tested and they're found to be negative, then they need to be pulled back into work there. There's any reason to keep them out of work. And hopefully as we get more tests, and they're, excuse me, the tests are the results are determined more quickly, hopefully that'll mean we might get a number of people back in 2 or 3 days rather than in 14, which will be one of the advantages of having the test.
Great. Thank you. Next question.
Yes, hi, Kathy. This is Thyra Austin. Good to hear from you. I had a question. In light of HIPAA and some of the other laws, is there any concern in asking employees to self-identify if they have the virus in order to protect your other employees?
Unless you are healthcare or you're administering their healthcare in your business for some reason, it's not a HIPAA issue. It is an ADA confidentiality issue, but that doesn't prohibit you from doing that. From all of the guidance that I've read, it is perfectly permissible to ask an employee if they have COVID-19, if they have been tested, or if they have a test result, and or if they're suffering from any of the symptoms of COVID-19. Now, I have heard a couple of cases with someone seeing someone in the workplace who is just coughing a lot and sweaty, but the person was temperature was taken and they didn't have a fever, but they were sent home anyway. But so you got to be careful on those things. But no, typically for most of you guys, HIPAA is not going to be in play, and it's going to be an issue of the keeping any information you receive confidential.
Great. Next question.
Kathy, thank you for being with us today. This is Martha Studstill. I own Uptown Gifts on Main Street in Columbia, a very small business. I have 10 employees, mostly part-time, and I've closed a store. And I think like many small employers, I don't have benefits for them, and trying to figure out that was the hardest decision, was how my employees are going to be impacted. Are any of these any of this legislation going to address hourly workers?
Thanks, Martha. That's a great question, and I think you are among the majority who are just in a very difficult place when you have 20 or fewer employees, and I'm pulling that number out of the air, but you're small enough that everyone matters, but you're not big enough where there are a lot of benefits that can happen under your profit margin. And so, again, you're not out there at all, and a lot of places like this have had to close. Many of these in this bill are directed specifically to folks who are hourly employees. The next bill may hit some other folks and expand it, but right now the real concern is that we have a ton of people in society who are hourly workers, who provide services, and who really have no safety net.
Okay. I know there's 2 keypads in the panel and a radio. I believe it's in Justice MVP.
If somebody can
I'll put it together
keep their phone.
Talk to you about it. Okay. Thanks.
When you look at this, it is a very it can be a heavy burden to employers to have to pay these things, but it is also a very tiny safety net to someone who may have no income. But yes, the act is intended to address heavily hourly employees. And some of the other legislation we're hearing about, with, for instance, $1,000 being given to people and that sort of thing, those are not intended to go to top executives and that sort of thing. It's intended to really hit the level where people are being hit. I'm sorry, I didn't mean to cut you off.
No, I was just I appreciate that clarification. But how are we going to find out about this? Will some agency contact us based on our quarterly reporting or something? Or, I mean, how will we find out what's available and how to address it?
What you're supposed to do, I sent you a link earlier it was from the end of last week when the first House version passed. I don't think there have been many, if any, changes because of the way legislation works. So I think this is essentially what the Senate passed. Carl is more than welcome to send that link to y'all with it's a summary of all the provisions. I have never seen anyone get a notice that says, for instance, you're covered by FMLA and you need to comply with it. It's just the law that it covers certain businesses, and you're essentially charged with knowing that. Now, that brings up one point. As I read this law, normally I would bet a ton of y'all are not covered by the Family Medical Leave Act because it's 50 or more employees. And then you have to have worked for a year for the company and had 1,250 hours. So it eliminated a band of people until they were more established employees. As I read this act, you have to have worked for your employer for 30 days, and that is the requirement. So if I'm reading this correctly, FMLA is going to apply to a whole lot of places it didn't before. Now, we'll watch for it and see if there's further definition of that. But as I understand it under this, if you've got employees who've worked for you 30 days, they may be covered by this. Now, that brings up a really, really good point here, and that it's not everyone's going to be covered by FMLA on this, even with the new legislation, because one of the things you have to be covered by FMLA is a serious health condition. And again, there are going to be tons of people that have to go out of work who are not going to have a serious health condition because they may be asymptomatic. I mean, I don't know what the numbers are right now, but there are a lot of people who are not made really sick by this, so they wouldn't necessarily be covered by FMLA. So keep that in mind, that just when you read that part of this summary, that you still may not, employees may not be covered by that. The same thing, and I may have said this earlier, is having COVID-19 is not automatically a disability, so keep that in mind. One of the other things we're seeing, though, on the other side of that is one of the things they've said is
the monitor would go
you have a
and that would go into your. But it might not.
Hey guys, we got to mute your phones, please.
Okay, which is right. But this would do an HDMI port. So then that was meant to that. All right. Well,
anyway, y'all let me know if you can hear me. But I think I was saying that it's not necessarily a disability by any means, so that's fact specific.
Good. All right. Well, hey guys, this is important. We can't hear, so if y'all could mute your phones, we would greatly appreciate it. Thank you. All right. We've got time for a couple more questions. So.
Hi, this is Barb Williams. Barb Williams, is there any liability for employers that do not enact a work-at-home policy?
No. Again, the CDC has recommended that anyone who can work at home. I've got in my office right now, I have a rotating policy, so I'm sending half the folks home and keeping an essential staff and then rotating them out. But not everyone can do that. There are a lot of businesses where it just doesn't work to have remote work. So, no, you're not going to be penalized if you don't do that. If you do it, there are certain recommendations that I would certainly make. Number one, making it clear that this is a temporary situation and that the employer has the right at any time to call the employee back into the workplace. A lot of people are worried about inefficiency or employees not working, and if you ever find that to be the case, you can just say, we're ending this and pulling people back in. Now, that said, that's good advice as long as we don't have any governmental entity require us to quarantine at home and only do minimal things. We've got a couple of jurisdictions where we're working where there are essential businesses, for instance, a nuclear plant or a pharmaceutical plant, where employees are having to carry letters with them that say, I work for this essential industry, and so I need to be able to commute to work and things like that. It is a very surreal time, but these things are happening. But, yeah, if you have a business where it doesn't work to have your employees work remotely, then that's just not an option. Even if you have one where they can, it's merely a recommendation.
Good question. Really good question. Anyone else?
Yes, I have a question. We have an employee who has a compromised immune system. I'm sorry, my name is Debbie Clark, and she is currently not in the office working. Are we required to pay her?
Is she working remotely?
No, she's her job does not allow that.
Okay. Then again, the answer generally is no. It would if she's an exempt employee, it would depend on like when she went out and that sort of thing. But generally, the answer is no. You're not required to pay her. This is what this most likely is an ADA accommodation for someone who is high risk. And did her doctor suggest that she go out or anything like that?
No, she did not. She is a type 1 diabetic, and I think we were just concerned about her.
I think it makes perfect. No. I think it makes perfect sense to send her out. But there is a distinction between someone who is truly a high-risk employee and people who are just afraid. If you can afford to let someone work or go home if they're afraid, that's something you can do. But there are both National Labor Relations Act and OSHA Act or OSHA implications there. And generally, if someone if it's not a reasonable fear, and right now it wouldn't necessarily be, unless you had widespread breakout in your workplace. But generally, you do not have to just let those people go home because they're afraid.
Okay. All right. I appreciate that. Thank you.
So I have a question.
Yes, ma'am.
Hi. This is Tricia Dunn West with Hospice Care of South Carolina. And I have a question. If an employee was showing symptoms of COVID and refused to be tested, is there anything an employer can do to mandate that?
Not that I'm aware of.
Okay, thank you.
That's a shame. But I assume you've quarantined that person?
They don't actually work on our staff. It's just someone that asked the question. I said I would put it out there.
Okay. Okay. Yeah. No, I'm not aware of anything. Now what you can do is if there's a belief that they may have it, what would happen, I don't know, but I think that could be reported to the health department and then let them follow up on it.
Very good. Thank you.
Dominic here. I've got a quick question. I came in late. I may have missed this, but I don't quite understand furlough, and is that something that's applicable in this situation in order for your employees to keep their health care? And this would be a very small company of less than 10.
It depends on your health care plan. One thing that's real important when you're looking at your health care plans is a lot of terms are defined in them, usually at the very beginning. And one of the things it defines is who can and cannot be covered by the active policy. If someone is furloughed, that may trigger COBRA. I'm not certain, but you want to fully comply with the terms of your health care policy, because if you don't and you do something for one or for a few, it could cause the entire policy or the entire plan to be wiped out, essentially.
Doesn't apply to us.
So, more specific.
I'm getting a review of my presentation back there.
Yeah.
Anyway,
sorry.
I'm sorry, Dominic. Go on with your question. I'm sorry.
Are more people doing layoffs or furloughs, or what are people doing out there with this?
It's really starting to evolve, and we're starting to see a lot. The questions are changing, which goes to exactly what you're saying. At first, it was more just about putting people out because of concerns about them having COVID-19. Now what we're seeing is employers are truly concerned about either because they have to close, because they have to reduce their ability to function, or other things hitting their economic side of things. So we're starting to get far more questions about the WARN Act if you close down totally, and furloughs and layoffs and reductions in force and whatever title you choose to put on it, that kicks into a whole different area. And one of the things we're looking at is, does this meet some of the exemptions under things like the WARN Act, where you have to give notice? If you do something where you have a reduction in force and you just pull out specific employees, you want to be sure that you can justify that and that there is no allegation that there's any discrimination or anything of that sort in who you pick. So those are normal analyses, but people are having to move on them quickly now. But we are hearing more and more about places closing, and just they may not be terminating business yet, but there are plans for that to happen.
Okay, thank you. Yeah, we're just kind of struggling here.
Everyone is, and it's a furlough is kind of a temporary layoff sort of vehicle, and we can all put different titles on it. It's just a matter of, and one of the things we're looking at is, okay, if you lay someone off and then 60 or 90 days later decide this isn't going to fly, we're just going to have to let people go. That used to mainly hit things like unemployment insurance and some of those things. But because of the changes that are going into place with some of these vehicles to get compensation, like the unemployment compensation, they're being temporarily changed. So the what you call it doesn't have as much of an impact right now, unless you're someone totally shutting a plant. That's one thing.
Okay, thank you very much.
All right. Well, I think we've got time for one more question. Anyone? And
Carl, this is not trying to solicit business at all. But one thing I'll say is we are really working to publish a lot of things and put things out that are useful. Some of them are available just to our clients. Some of them are available to anyone who wants to go to our website. But if you go to Ogletree.com, for instance, we have a list of frequently asked questions that we've just updated recently. I don't know if the new version is published, but you can get those without being a client, and they go through a lot of these issues, pay issues, notice issues, and things like that we know people are worried about, and you may find that to be a useful tool. And so I encourage you, if you look at it, and if you can use it, go for it, because that's one reason we put it out there.
Great. Thank you very much. All right, one last question.
Kathy, this is Farrah Stewart. I'm with UMS Affiliates. It's been a while, but hey.
Hey, how are you?
Good. I was with Lexington Medical Center a while back and used to speak with at our conference.
I remember you well.
Yes. Have you heard anything, or is there any rumblings about potentially the IRS loosening up? Granted, all of our 401ks are in the tanker now, but loosening up some of the restrictions relative to being able to get to funding without penalty?
I have decided I'm not going, between the flood and this, I'm not going to be able to retire until I'm 200.
Yeah.
But I have not heard anything about that particular aspect. And Farrah, quite frankly, we're on the front end of this, and I think everyone's scrambling to try to look at what's realistic and what can really make a difference. I did hear, and the irony of this is kind of bizarre, but I did hear this morning the IRS is granting, I believe it's either a 60 or 90-day extension to pay taxes for businesses and for individuals. Now, they didn't give an extension to file your taxes, which it makes no sense to me when people are scrambling and no one has time for that right now. But I understand there is an extension there, and I believe Governor McMaster or the appropriate entity in South Carolina has actually given an extension to file South Carolina taxes.
Yeah, they did to June 1st, I believe.
Yeah, but that's all I'm aware of as far as kind of that piece yet. We are on the tip of the iceberg as far as things that are going to be done.
Right. Okay. Thank you, Kathy, and y'all stay well and stay safe.
Thank you. Guys, this has been great, and Kathy, I can't thank you enough for taking the time to be with us and being so gracious with your own time. So the Chamber's got on our website, we've got a bunch of links for information. We will continue to be looking at topics to have additional calls. And I'm sorry that we were trying to do a webinar, but a lot of those things are being overrun right now. So thanks for your patience on the calls. But Kathy, thank you again, and appreciate everybody. And we'll put a link as well, Kathy, to Ogletree's frequently asked questions as well. So thanks again very much, and we'll talk to you soon.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.